Lawyers are supposed to represent their clients zealously, but they're not supposed to be overzealous in being zealous. What does that mean? What are the boundaries? And is there a difference between being overzealous and being creative? Let's talk about it. Hey, this is Overzealous, author of the book Courtroom Confidential, and I'm putting your brain on law. Just a reminder, I'm not giving legal advice, just talking today about how I dealt with a potential catastrophe in a trial and turned it to my client's advantage. If you like the video, hit that like button and subscribe to my channel. If you're a lawyer and you need help researching legal issues and drafting pleadings, including motions, briefs, petitions, and extraordinary writs, hire me to work under your supervision. My contact information is in the description to this video. So here's the situation. I was representing a client, let's call him Al. Al was charged with a very serious felony, armed burglary of an occupied dwelling. He was looking at doing 30, 40 years in prison. So how did Al find himself looking at decades worth of eating bologna sandwiches and looking over his shoulder? Al's Uncle Ray was a notorious drug dealer who kept a ton of cash in his apartment. Al knew that Ray was a notorious drug dealer who kept a ton of cash in his apartment. So Al decided to bust into Ray's apartment while Ray was there, steal all the cash, and just for fun, tell Ray he was going to blow his head off if Ray called the cops. Ray called the cops. The state had a strong case against Al. They had video of the burglary, Ray ID'd him, and Al's confession to the police included details of the crime only the perpetrator would have known about. But because the state and the cops hated Al's Uncle Ray, I was able to work a sweet deal with the prosecutor. No prison time, which was amazing, and just 2 or 3 years of home confinement followed by probation. I ran the deal by Al, and Al took it, so I set his case for a plea at the beginning of the judge's 2-week trial period. And here's how that works. You call sweet, nice Donna, Judge Strickland's JA, judicial assistant, and tell her your client's going to plead. Pleasantly, Donna says, "Great, I'll set her for a plea the morning of the first day of the judge's trial calendar." The first day of the judge's trial calendar rolls around. Al and his cellmates are laying around their pods at the 33rd Street Jail, which used to be a cow pasture that had the craziest, rockingest parties before Orlando grew into the mess it is today. The sheriff's office rounds up the guys who were set to appear in court and drives them over to the Orange County Courthouse, where they're put in holding cells in the courthouse basement before they're brought up and seated, like one big happy family of felons, in the courtroom's jury box. This assumes you've gone over the paperwork you have to go over with your client a week or two, I don't know, maybe the day before the plea, which I did with Al. So I'm sitting in the courtroom watching as everyone except Al is brought up. That's usually a bad sign. It definitely was that day. I sidle up to Howard, Judge Strickland's main court deputy. They used to call them bailiffs in Florida. And when I ask him where my client is, Howard says he's got some bad news for me. Al's not there because after listening to all the jailhouse lawyers, his fellow inmates, Al's decided he's not pleading. Nope, he's going to trial because a bunch of dumbasses who know nothing about his case, not to mention the law, told him he's got a great case and he's definitely going to win if he goes to trial. No big deal, I figure. Strickland's a mellow, easygoing judge who's not known for doling out harsh sentences. I'll just go to trial, and if Al's convicted, Strickland's not the type of judge who's going to sentence him to 30 or 40 years like Dorothy Russell would. But it's not long before Stan the man tells me he can't try Al's case because he's got to try a murder case which is going to take all 2 weeks of his trial period. Instead, he tells me he's farming me out to another judge. That judge is Dorothy Russell. I don't want to give you the wrong impression about Judge Russell. I got along great with her. She always made sure I got paid by making payment to me a condition of my client's probation. I always made her laugh in court by saying cute, stupid little things that made her laugh. She and I used to cut up at lawyer-judge parties. She never really hammered any of my clients, even though she had a reputation for being a brutal sentencer. And every time he appeared before her, she'd say, "Hey, Zuzlas, how's it going?" So yeah, me and Dot were good. That day, though, was different, and I knew why. About a month before, I had a pretty minor case set for Dot's trial calendar. I think it was a third-degree felony, maybe first-time cocaine possession. I needed a continuance to take depositions. The prosecutor agreed, so it was a foregone conclusion that Judge Russell was going to continue the case. Well, I kind of blew off the calendar call. That wasn't a big deal because I'd filed a motion to continue, and the prosecutor would simply tell the judge we'd agreed to a continuance and Judge Russell would continue it. But if instead of going to court, I went to the world's longest yard sale with my girlfriend. Now, if you saw my girlfriend, you'd understand why I blew off court. Anyway, I think Dot was a little miffed about it because when I walked into her courtroom to try Al's case, the atmosphere in there had the temperature of a meat locker. There was no, "Hey, Zuzlas, how's it going?" Instead, after I asked Judge Russell if I could take a minute to run down to Judge Rodriguez's courtroom to tell him I was in trial in front of her, there were these words covered with judicial frost: "No, I can't let you out of my sight because I don't know if you'll ever come back," which I thought actually was pretty funny, but I didn't laugh. Instead, I was calculating how I was going to use what Dot said to get Al's case back to Judge Strickland. What Judge Russell said next made that easier. Dot stared at Al. "So, you want a trial? Now you're going to get your trial, mister, and if you're convicted, which probably was going to happen, I'm giving you 30 years. Al didn't say anything to Judge Russell. He did, however, turn to me and sputter, I want the old deal. Can't we just go back to the other judge?" He was talking about Strickland. "No," Judge Russell responded. "I've got you now." Actually, I had Judge Russell now. While I was holding up Al, who was sagging at the knees, literally, I told Judge Russell that I needed time to file a motion for her to disqualify herself from Al's case because, based upon what she'd said, she had a prepossession, that is, a prejudice against me and my client. All Judge Russell said was, "Motion denied," which I said was only further proof that she was prejudiced. I mean, come on, she doesn't even give me the chance to file a written motion and have a hearing on it. Now I told her I needed to file a second motion to disqualify, which Dorothy denied without giving me time to file a written motion, have a hearing, or go to lunch with her. If everyone in the courtroom was thinking, "Well, that didn't work, time to try the case," they were wrong. I had a big surprise for everyone. I just needed to be patient and do nothing, which is exactly what I did, because doing nothing got me everything. How? Let me explain. I laid a legitimate basis for disqualifying Judge Russell. There was a plaque on the front of her bench that said, "Professionalism demands respect." Telling me she couldn't trust me was definitely disrespectful. Telling Al she was going to give him 30 years without hearing any of the evidence or having lunch with me showed she was, prejudiced and refusing to give me the opportunity to file my motions and have a hearing on them was just further evidence that she won't listen to anything I had to say in my client's defense. She just wanted to get the trial and Al's life over with. So you're thinking I didn't have to do anything else because even if Al was convicted, I win on appeal because of the whole disqualification thing, right? Wrong. People convicted of serious felonies usually win one thing on appeal: bupkis, which is to say, nothing. In Al's case, the Court of Appeal would say, yeah, maybe the judge was out of line, but you know what? No harm, no foul, because the evidence of guilt was overwhelming, so any error Judge Russell made was harmless. In other words, asking the Court of Appeal to reverse Al's conviction would be like asking Hitler to go to a bar mitzvah. That wasn't going to happen. Only one thing would work, and that thing was doing nothing, which is what I did, just probably not in the way you're thinking. So, Judge Russell has the court deputies bring in the venire members. That's the crowd of people you choose the jurors from. And the prosecutor began her voir dire, in the South it's pronounced voir dire, which is the insufferably boring process in which you and the prosecutor take turns asking the same old, stupid questions in a largely vain effort to find the magical jurors who'll give you the verdict you want. Can you be fair? Will you listen to the evidence? Do you promise to follow the judge's instructions? Ay. The prosecutor does her voir dire first. After the prosecutor in Al's case droned on for about an hour, it was my turn. Dot, the prosecutor, the court deputies, and maybe a few of the strangers trapped in front of me expected me to stand up and kick off my voir dire by introducing myself. Good morning, ladies. Good morning, ladies and gentlemen. Well, folks now, ever since Obama started using that corny word in a disingenuous attempt to sound relatable. I'm Overzealous and blah, 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 blah. Except all I did was sit there. Didn't talk to my client, didn't look at anyone, didn't scratch my head, pull out a snack, or even do a crossword puzzle. I just sat there. It was an important part of my plan, which suggests there were unimportant parts, which there weren't, so it was part of my plan. The plan was do nothing, refuse to participate in the trial at all, and that's what I did. After a very pregnant pause, Judge Russell asked me if I was going to perform my voir dire. I said, not only am I not going to participate in voir dire, I'm not taking part in any part of this trial because it's a sham. And it's a sham because you've clearly shown that you're prejudiced against me and my client. You won't even give me the opportunity to file motions to have you disqualified because you're prejudiced. You refuse to give us a hearing on those motions, which, by the way, is a denial of due process, and on it went, climaxing with, I'm not doing anything in this trial. Checkmate. Judge Russell had no choice but to declare a mistrial, remove me from the case because every criminal defendant has the Sixth Amendment right to competent counsel, appoint another lawyer to represent Al, continue the case because the new lawyer would need time to get up to speed, and send it back to Judge Strickland, which is exactly what Dot did. Someone filed a grievance against me with the bar. At a party a couple of years later, Dot told me it wasn't her, which I believe because we were always cool with each other, and she added that she understood I was just trying to save my client's ass. The bar ended up suspending me for a short period of time for being overzealous, which I couldn't agree with less. I mean, please. As a lawyer, you're your client's legal bodyguard, and that means you put your ass on the line to protect your client's rights. Al had the right to a fair trial, which he wasn't going to get in front of Judge Russell. She had already decided to lock him up for most of the rest of his life, and she wouldn't even let him file important motions and give him the opportunity to be heard on them. 99.9% of lawyers wouldn't do what I did, but I'd always been more comfortable pushing the boundaries and being part of the creative 1/10 of lawyers. I wasn't scared of being held in contempt and thrown in jail. In fact, I wasn't scared of anything in that courtroom. I just did what I had to do to protect my client, and I actually had fun doing it. Look, here's what I believe. If you're not willing to do things like that, then you can't really call yourself an advocate for your clients. What do you guys think? Post your comments. Thanks for listening, and I'll see you next time.